Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about amicus briefs, or amicus briefs, depending on which way you'd like to pronounce it. So I'll have more on that in just a moment. An amicus brief, sometimes referred to as amicus curiae, is literally a friend of the court. In other words, it is filed purportedly to assist the court. And indeed, in common practice in the 1800s and 1900s, that's what amicus briefs were for. They were to offer insights into the law or into the public policy that may not have been considered at the trial court, or may not have been considered otherwise. So the purpose of them was always to try and help the court reach a just result. But over the last 100 years or so, amicus briefs have really become just another tool of argument. And sometimes they're a way that clever people try to evade the number of words that you get in an appeal. Now, you may not know this, but when you file an appeal, you only get so many pages to argue before the court. In other words, if your appeal is limited to 12,000 words, you have to say everything you need to say in 12,000 words. And there are certain things that are required, and so it can be quite difficult sometimes to get everything in within the word count that you have in an appellate brief. So one way that people sometimes like to use to advance other arguments, maybe arguments that aren't central to their appeal but might still help them, is to enlist an amicus to file a brief in support of their position. Who files these briefs? Normally, it is people who are interested in the outcome but are not parties. So, for example, trade associations and unions and politicians often file friend of the court briefs. You may recall in the first New York State Rifle and Pistol Association case, some senators filed an amicus brief. The fact is that most of the time when people file amicus briefs, they bring up arguments that aren't brought up by the parties. I'll give you an example. Let's suppose you have a Fair Debt Collection Practices Act, and the court is called upon to determine whether or not in a particular scenario the Fair Debt Collection Act covers attorneys who are debt collector attorneys. And it has to reach this decision in the appeal. Well, then you might get not only the briefs from the individual lawyers involved in that case, but you're also going to get briefs from the trade associations. Bankruptcy attorneys might chime in and say, hey, this is one way that the court can answer this question that, advances public policy. You might have banks that would get involved in that kind of situation. But whoever it is, the idea is that they are going to advance arguments that have not been made by the parties themselves. So obviously, that requires them to read the briefs of the parties to know what arguments are being advanced. As I said, the purpose of these is to advance a different insight into the problem before the court. In other words, not only is your ruling, judge, going to have an impact on the two parties, but what you may not realize is it's going to have an impact far beyond that, and these are the parties who are going to be affected, and these are the effects that might happen, so this is why we're concerned. And that's perfectly appropriate. It's perfectly appropriate to let the court know that there are other parties that may be affected and why they might be affected. The next question is, do they really have an impact? Well, I can tell you that when I worked as a clerk at the Missouri Supreme Court, my experience was that if they had an impact, it was very slight. Usually judges decide the case that's before them, and they decide it on the basis of the law and the public policy if it's going to have an impact beyond that, then they'll deal with that impact in the next case, because courts decide cases one case at a time. That's how they do things. It is said that Ruth Bader Ginsburg, when she was an appellate lawyer, wrote a lot of appellate amicus briefs, and that her briefs were short but very impactful. I have no way to verify that. There are a lot of urban legends in the lawyer profession, just as there are in other places, and sometimes after a Supreme Court judge passes there, you get a lot of people out there trying to buff the halo, and I think that may be the case in that. But whatever impact they had, I'm sure they were very well written, because Judge Ginsburg was a very good legal writer. I don't think personally that amicus briefs really carry a lot of weight. The reason I say that, I've written 2 amicus briefs in my career. The first one was in front of the Second Circuit. I was acting as an amicus for the American Association of Respiratory Care, and I was advocating for on a specific issue related to the calibration of pulmonary instruments. And we were advancing the idea that this should be central to Medicare's payment, that equipment that's used to test people has been calibrated. The Second Circuit pretty much ignored my appellate brief because they reached exactly the wrong answer in that case. But, you know, it was important for the association to file it, and I thought we did a very good job of advancing the issues in that case. Now, the second case that I filed an amicus in was in the Eastern District of Missouri, and it was on behalf of a group of farmers. And again, the appeal came out the wrong way as far as they were concerned, but I was not left with the feeling in that case that my brief had been ignored. I was left with the feeling that the law that the court found in that particular case was a great deal more important than anything that any of the amicus briefs had raised. It's important to realize that amicus briefs have limitations and that they are not a be-all or end-all to get you a better result in an appeal. In fact, in the Seventh Circuit, the Seventh Circuit is generally not very fond of amicus briefs. Let me read you from Judge Posner, who was the chief judge, a little bit of an opinion where he talked about amicus briefs. Here's what he said. This court has held that whether to allow the filing of an amicus brief is a matter of judicial grace. The judges of this court will therefore not grant rote permission to file such a brief, and in particular, they will deny permission to file an amicus brief that essentially duplicates a party's brief. The reasons for the policy are several. Judges have heavy caseloads and therefore need to minimize extraneous reading. Amicus briefs, often solicited by parties, may be used to make an end run around court-imposed limitations on the lengths of parties' briefs. The time and other resources required for preparation and study of and response to amicus briefs drives up the cost of litigation, and the filing of an amicus brief is often an attempt to inject interest group politics into the federal appeals process. So I think that does a pretty good job of explaining exactly what the problem is with amicus briefs. The problem is that they can be used as a means to expand one party or the other's briefing. And I think that may be one reason why courts tend to either deny filing them, as the Seventh Circuit routinely does, or limit their application. The only court that doesn't really limit amicus briefs, and sometimes gets 50 of them in a case, is the U.S. Supreme Court. Now, whether those amicus briefs actually have impact or get, filed in the file and that's all that happens to them, I can't say. But I can say that every now and then you'll read in a Supreme Court opinion where they discuss what one or more of the amicus parties say. So the reason this came up today is because Amber Heard, on behalf of Amber Heard, an interest group filed an amicus brief in her case. And as is frequently the case when you get somebody who is writing an amicus brief who doesn't understand the appellate process, the amicus brief does a couple of things that no brief should ever do in a court of appeals. One of the things that a brief has to attack, in both for the parties and an amicus, is the legal rulings in the case. In other words, this piece of evidence was admitted erroneously, or this piece of evidence should have been stricken, or this testimony should have been allowed, or the judge erred when it determined that this question called for hearsay. Those are the kinds of legal errors that appellate courts deal with all the time. And the reason that trial court error is the focus of all appellate briefing is that the appellate court is overseeing the judge. The appellate court is not usually overseeing the jury. In our system, the jury is the finder of fact, and as the finder of fact, whatever facts it finds are found, and those become the facts of the case. So when you have an amicus brief that attacks the jury and says the jury didn't understand, the jury didn't get a full picture, the outcome was wrong and the outcome will harm other parties, you have to be specific about what trial court order or trial court ruling is involved. And from the brief snippets of the brief that I have read, and you can no longer get it because once the brief was sort of laid bare on YouTube by a number of other people, it became very difficult to get it because they restricted access to it, which frankly they shouldn't do. The court should require them to make their amicus brief public, because the public has a right to know what these interest groups are saying, and very, very few things in law are litigated behind closed doors. So the other thing you can't do is you can't re-argue things that were argued at the trial court and you lost, and unless you're tying the appeal to that. And generally that's the duty of the party. It is not the duty of the amicus. The amicus in this case essentially parroted, in many respects, at least from what I saw, they essentially parroted the original brief of Ms. Hurd. That was not a good call, and it was not a good look. Whether or not it will be useful to the Virginia Court of Appeals, I have no idea. But I do know that anybody who watched that trial has come to different conclusions about Amber Heard's credibility than that brief does. And that's one of the things that the brief does, is it attacks the jury's finding on credibility. And again, that's not something you can do. So that's sort of the lay of the land with regard to amicus briefs. If you have any questions, leave them in the comments down below. And I'd love to hear comments on the new intro that I'm doing and the new end card that I'm doing. So if you have any questions, leave them there. Thank you so much for watching. I will catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.